How does preponderance of evidence work? Imagine walking into a courtroom where two sides present their stories. Each side believes they are right, but how does the court decide who wins? This is where the concept of preponderance of evidence comes into play. It is a standard used mainly in civil cases to determine which party's version of the facts is more likely to be true. So, what does this mean in practical terms? The party that has the burden of proof must show that their claim is more probable than not. In simpler terms, they need to demonstrate that there is a greater than 50% chance that their version of events is correct. Picture a balance scale where all evidence from both sides is placed. If the scale tips even slightly in favor of one side, that side has met the preponderance of evidence standard. For instance, if a jury believes there is a 51% likelihood that the plaintiff's claim is true compared to the defendant's version, the plaintiff wins the case. This standard is less strict than the beyond a reasonable doubt standard used in criminal cases, which requires a much higher level of certainty. The focus of preponderance of evidence is not just on how much evidence is presented, but also on how convincing that evidence is. A single credible witness or a well-documented piece of evidence can outweigh numerous weaker testimonies. The fact finder, whether it is a judge or a jury, evaluates all the evidence and decides which side's story seems more believable. In civil disputes such as personal injury claims or contract breaches, this standard is essential. The party initiating the lawsuit, usually the plaintiff, carries the burden to prove their case by this standard. If they cannot tip the evidentiary scale in their favor, they lose the case. Overall, preponderance of evidence requires that the fact finder be convinced that the claim is more likely true than false. This makes it the most common and easiest burden of proof in civil litigation. Understanding this concept is key to grasping how legal argumentation works in courtrooms.